Welcome to meeting number 87 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics.
Chambre des Communes. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. I would like to make a few comments before the business of the committee starts. For the benefit of witnesses and members, please wait until you're recognized by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. Although the room is equipped with a powerful audio system, feedback events can occur. These can be extremely harmful to the interpreters and cause injuries. A reminder that comments between members should be addressed through the chair. Aujourd'hui, nous avons les mêmes témoins.
Today we have the same witnesses for 2 hours to talk on 2 different topics. For the first hour, pursuant to Standing Order 103H, we will receive a briefing on the annual report and other reports of the Privacy Commissioner. Then, for the second hour, the committee will resume its study of social media platforms.
Socio. I'd now like to welcome our witnesses today from the Office of the Privacy Commissioner of Canada, Mr. Philip Dufresne, who is the Privacy Commissioner of Canada, and Mr. Michael Maguire, Director, Personal Information Protection and Electronic Documents Act Compliance Directorate. Welcome, gentlemen, to the committee. Commissioner, you have 5 minutes to address the committee. Please go ahead, sir. Thank you.
Bonjour, Monsieur le Président, Mesdames et Messieurs, les membres.
Hello, everyone. Good afternoon, Mr. Chair, members of the committee. I am pleased to be here today to discuss my 2022-2023 annual report to Parliament, which highlights the important work that my office is doing to protect and promote the fundamental right to privacy in a time of unprecedented technological change. It is encouraging to see this continued focus on the importance of privacy as it impacts virtually all aspects of our lives. Many of the public interest issues that you are seized with as parliamentarians, children's rights, online safety and cybersecurity, democratic rights, national security, equality rights, ethical corporate practices, and the rule of law, all have privacy implications and, I would argue, all depend on strong privacy protections.
Routine activities of daily life can also raise privacy issues, as you will see from some of the work and investigations that my office has conducted this year. For example, socializing online, using mobile apps, getting packages delivered, or going to the checkout counter. Since my appointment as Privacy Commissioner in June 2022, I've identified strategic priorities for my office to help frame our work over the past year and guide the way ahead. These include addressing the privacy impacts of the fast-moving pace of technological advancements, especially in the world of artificial intelligence and generative AI, protecting children's privacy, and maximizing the OPC's impact in fully and effectively promoting and protecting the fundamental right to privacy. À l'appui de ces priorités, nous avons
To support these priorities, this past year we have engaged extensively with our domestic and international counterparts to identify and undertake collaborative opportunities. We have also continued to advocate domestically for the modernization of Canada's privacy laws. I was honored to appear before the Standing Committee on Industry and Technology last week in the context of their study of Bill C-27, the Digital Charter Implementation Act 2022, where I made 15 key recommendations needed to improve and strengthen the bill. I was pleased to see a number of them endorsed by Minister Champagne in the form of amendments that will be put forward to the committee, and I look forward to the work of Parliament in reviewing this important bill.
Of our compliance work from last year, we accepted 1,241 complaints under the Privacy Act, which represents an increase of 37% over the previous year, and 454 under the Personal Information Protection and Electronic Documents Act, or PIPEDA, which was a 6% increase from the year before. One of the public sector investigations that is highlighted in this year's report involved Canada Post's Smart Mail marketing program. Our investigation revealed that Canada Post builds marketing lists with information gleaned from the envelopes and packages that it delivers to home across Canada and makes these lists available to advertisers for a fee. We found that this contravened the Privacy Act, as it had been done without the knowledge and consent of Canadians. We recommended that Canada Post stop its practice of using and disclosing personal information without first seeking authorization from Canadians. As a possible solution to remedy this matter, we recommended that Canada Post send a mail notice to Canadians to inform them of this practice and to indicate an easy way for Canadians to opt out. Until the tabling of my annual report, which made this decision public, Canada Post did not agree to implement this solution. After the report was made public, Canada Post issued a statement that it would review its policies, and I would expect Canada Post to comply with the Privacy Act, and I look forward to hearing from them on the next steps to resolve this matter. Le rapport fait également état de certaines de nos enquêtes.
The report also highlights some of our private sector investigations from last year, including our investigation of Home Depot's sharing of the personal information of customers who opted for an electronic receipt instead of a printed one at checkout with a social media company. Home Depot has since stopped that practice and implemented my office's recommendations. This case underscored the importance of businesses obtaining meaningful consent to share customers' personal information. Another important area of our work is addressing breaches in the private and public sectors. We remain concerned about possible underreporting of breach incidents in the public sector. The number of reported breaches fell by 36% to 298 last year, and only one of those reports involved a cyber attack. This compares to 681 breach reports from the private sector, of which 278 were cyber-related.
Breaking policy work provided advice and guidance to organizations in both the public and private sectors on privacy matters of public interest and importance, and continued to provide advice to Parliament. We know that privacy matters to Canadians more today than ever before, and that they are concerned about the impact of technology on their privacy. Our latest survey of Canadians found that 93% have some level of concern about protecting their personal information, and that half do not feel that they have enough information to understand the privacy implications of new technologies. This is why the work of my office to deliver concrete results that have meaningful impacts for Canadians and privacy in Canada is so important. In closing, I would like to thank this committee for its work over the years, including the many reports and recommendations in the field of privacy. I cite them often, and we certainly consider and consult them very often, and I know Canadians do as well. I look forward to continuing our efforts to ensure that privacy rights are respected and prioritized by government institutions and businesses alike, and to position Canada as a global leader on privacy. And I would now be happy to answer your questions.
Merci, Monsieur Dufresne, pour votre...
Thank you very much for your opening remarks. Before we move on to our questions, I would like to welcome a new analyst who is going to be working with our committee, Maxime, who will be joining Alexandra as one of our analysts. We'll start with Mr. Barrett. You have 6 minutes, please.
Well, thanks very much, Chair and Commissioner. Thank you for joining us. Mr. Maguire, thanks very much. I'd just like to take a moment to address Monday's committee meeting. We had a different commissioner here. We had the commissioner of the RCMP to address a serious issue. And before the meeting got underway, we had the Liberal Vice Chair move to adjourn the meeting. It was an incredibly important topic when we had the commissioner of the RCMP to address concerns that were raised in media last week with respect to the Prime Minister's SNC-Lavalin scandal. This is where the Prime Minister was found guilty of breaking Canada's ethics laws.
Mr. Barrett,
and
I'm just going to ask you, we've got Mr. Dufresne here.
Yep.
If you want to keep it relevant, please.
Yep, thanks very much, Chair. We have a Prime Minister who broke Canada's ethics laws, and the RCMP requested documents, and the Prime Minister used cabinet confidentiality to obstruct the release of those documents. So this is an issue that we're going to have to revisit at this committee. And it's of high importance to Canadians that they're able to have confidence in their democratic institutions, and no one is above the law, including the Prime Minister. With that said, Mr. Dufresne, I appreciate your opening comments, and particularly with respect to the Crown Corporation Canada Post. I think all Canadians expect them to follow the Privacy Act. And I am heartened that following your investigation into Home Depot that they complied with your instruction. And while I understand that Canada Post is reviewing the situation, I think it's very clear that they should also comply with your instruction. Have there been instances in Canada of people's data being scraped and collected by foreign governments for nefarious purposes that you've been made aware of?
We have issued some investigations, one involving Clearview AI, where you had an organization that was scraping the images of Canadians online, creating what was described as almost a permanent lineup of facial identification. So we found that this was a violation of the privacy legislation and made recommendations to the organization. The organization ultimately decided to depart Canada. So that was a high-profile instance where there was a concern. We are continuing to monitor this situation with international colleagues. We have recently issued a statement on data scraping and calling upon social media organizations to take steps to protect the information, to inform, to have some measures. We also highlighted some steps that individuals can take as well. So it is something that certainly we are focused on.
Is it a reasonable concern of Canadians that their personal information or biometric data could be taken from social media platforms and then used by foreign state actors, hostile foreign governments, to perpetrate intimidation on diaspora communities from those countries? And I want to be specific. There are concerns that are well known about the national security law that was passed by the dictatorship in Beijing that is germane to the company ByteDance, which owns TikTok. So this is an issue, a very popular social media app, and people are concerned about the risks to their privacy and personal information. We've seen governments suspend the use of this app on government devices. How concerned should people be about using this app on their personal devices, or their children using it on their personal devices?
Well, two things, Mr. Brett. In our statement on data scraping, which is dated August 24th, 2023, we talk about some of the risks, some of the privacy risks in terms of data scraping, and some of them include targeted cyber attacks, identity fraud, monitoring, profiling, and surveilling individuals, unauthorized political or intelligence gathering purposes, or unwanted direct marketing or spam. So there are a number of risks, which is why we are calling on social media companies and indeed all organizations to respect privacy obligations. And we set out a number of ways in terms of risk mitigation techniques that social media companies can and should take to protect that information from bad actors that would scrape the information. So we also, again, highlight some practices and advice to individuals. Although it is not on individuals to protect themselves exclusively, the organizations have a duty, and their advices that can be taken. In terms of, you made reference to TikTok, I have initiated a commissioner-initiated complaint with respect to TikTok last year. We initiated this in February, and I am moving forward with my provincial colleagues from Quebec, Alberta, and British Columbia. This is a joint investigation, and we have initiated that to look at the privacy practices, and we are looking forward to completing this investigation, hopefully by the end of March 2024.
So with just about 30 seconds left, I hope we have the opportunity to come back to your strategic goal of protecting children and finding out more about how you plan to do that, and any examples that you've uncovered with respect to children being targeted or manipulated, particularly by social media apps or companies, particularly with respect to foreign state actors. But I think that's close to the end of my time. Thank you very much.
Okay, thank you, Mr. Barrett. Next, we go to Madame Fortier pour 6 minutes, s'il vous plaît. Commencez.
Merci, Monsieur le Président. Et avant de...
Thank you very much, Mr. Chair. And before asking my questions, I would like to clarify certain things. I believe that on Monday the chair abused his authority, and I would like to come back to certain procedures and rules that I believe were misused.
Long-standing procedures and practice that govern the House of Commons standings committees and the process for undertaking subject matter studies, the process for moving motions, and the role of the chair are outlined in the House of Commons procedure and practice, which is what I debated during the suggestion and motion to adjourn the meeting. I will remind that page 1061 of the third edition, House of Commons procedure and practice states, a motion is needed to submit a proposal to a committee and obtain a decision on it. A motion is moved by a member to have the committee to do something, order its chair and staff to ensure that something is done in order, or express an opinion on a matter, a resolution. Page 1011 of the same edition states, the committees then undertake to define the nature and scope of the study, to determine how much time they will devote to it, and whether or not they will report their observations and recommendations to the
Madam
House.
Fortier, just for a second, please.
I'm almost done.
I called Mr. Barrett on relevance before, and
Yes, sir.
I'm going to do the same thing to you. We've got Mr. Dufresne here to talk about his report, so I'm going to give you a little more latitude, but...
I'm almost done. Okay. Thank you very much, Chair. And lastly, page 1039 states that the Chair calls meetings and decides on the agenda for the meeting in compliance with instructions from the committee. The process outlined above was not followed in the circumstances of the meeting scheduled for October 23rd, 2023, which was last Monday. Therefore, I cannot wait for us to debate that motion, and then we will be able to resolve what happened on Monday. Alors, merci beaucoup de m'avoir.
Thank you very much for giving me the time to share my thoughts on that as well. And secondly, thank you, Monsieur Dufresne, for being with us today. It's good to be able to see each other in person, and I would like to congratulate you. I know you've been in your role for a while, but I'm pleased to see you in that role. You mentioned that you have a backlog of complaints and that it was hindering your resources. Could you explain an action plan or what you will do? Because things are more complex, whether it be about having things be more automatic. Thank you very much, Ms. Fortier, and it is a pleasure to see you in person as well. We looked at that early on in my mandate because the quality of decisions is important, but it needs to be done in a reasonable time frame. And so we focused on this. We identified a need for additional resources, and we received them from Parliament, and we are grateful for it. We looked at all levels. We looked at our internal processes. Could we have better ways of doing things? Do we have good risk management? Could we use technology? Could we have incentives to encourage organizations to reach a decision more quickly? I believe in a more proactive resolution of issues. And so we talked with the different stakeholders to understand what the obstacles are. I don't only want to say when there are issues with privacy, I also want to talk about positive things done by the government and by the industry, because that creates positive incentives. And so I think we have some opportunities here, and that's why I mentioned it in my 3 operational priorities: technology, children, and efficiency at the office. And so we'll do all that we can to make improvements, and we have started to see improvements. Question: you piqued my curiosity when you mentioned that in the private sector there are some companies that aren't reporting. Do you think there are things that we should examine, legislation or regulations? Currently, in the public sector, it comes from Treasury Board, and in the private sector, there are legal obligations. I think that having binding legal obligations is useful because it becomes an incentive. So it needs to be done for both the public and the private side. And there also needs to be better communication and a better understanding of the criteria for reporting. Sometimes organizations don't understand and they think that the risk is lower than what it actually is. There were organizations that said, oh, we didn't report anything because we thought that the risk wasn't high enough. And then through talks, we were in a bit of a disagreement and we said it's a financial risk or a reputational risk or the information was sensitive. And so there's some awareness raising that needs to be done and there needs to be the tools to do that. But we will continue to work on it and to encourage institutions to focus on that because we can give advice, we can work with these companies, and we could work with Canadians as well because we want to protect victims. Thank you, Monsieur Dufresne. Thank you, Ms. Fortier. Thank you for your comments. Mr. Villemur, you have 6 minutes. Thank you very much, Mr. Chair. Thank you, Monsieur Duhem, for being with us. I read the report in depth and I found it great. After reading the report, I was wondering, what are your current concerns regarding the future of privacy? Because there are people in my riding who have been talking to me about it a lot. And risks change. So what are your current concerns? Answer. I've been thinking about how we can better communicate with Canadians. And what you did in your riding and speaking with people was a good thing. We want to equip people so that they understand what's going on. Technology is advancing rapidly with AI and generative AI, and Canadians sometimes feel like they're falling behind because things are changing so rapidly. And some people think that we can't protect privacy because technology is advancing too rapidly. I think it's important to say to people that privacy needs to be protected. It can be done. Institutions can do it. People can do it. And legislation cannot be amended at the same speed as technology advances. And so legislation needs to be based on principles that can be applied to new technology. We need to have assessments of privacy, and I also believe in transparency, that we need to communicate better. Why is their information being used? Often consent clauses are hard to understand even for experts. And people are exhausted. And in investigations, including the one in my report, whether it be with Canada Post or Home Depot or Tim Hortons, sometimes people are shocked by what's being done with their information. And so in discussions that we're having with organizations, we're telling them to be proactive. Make that information easily accessible. Because sometimes they'll say, oh, our privacy policy is there, it's on our website, it's at the post office. And we tell them, well, you're putting the burden on Canadians to look for that information, whereas you're better placed to share it. This is something that really interests me, because often we arrive on a website, for example, Canada Post, and we give our consent because it's Canada Post. But most of the people that I've met and who came to the activity that I had organized, they don't understand what they're consenting to. Things are not often explicitly stated what can be done there. I think that there needs to be more public discussions and transparency, and there needs to be obligations for transparency. Because the issue is made even worse with artificial intelligence. People can say, I know that my data is being used by a certain entity, but does a person really know what can be deduced about them? Sometimes what can be learned with with our postal code and with our musical interests, one can deduce our sexual orientation or how much we earn, and people don't understand that. And with C27, I recommended that there be an obligation for transparency. And with AI, that we can ask for an explanation. Often, well, now we're talking about when there's a significant impact on people, and I asked that that be removed because more transparency is better than less. We need to find easy ways to explain things, and that's one of my mandates. There's a lot of information on our website, and we try to explain things as best we can, but I think that we can do more. And we'll also talk about children. I think that it needs to be adapted. I think that there are more and more people that are saying the toothpaste is out of the tube, so what can we do? But should people give up on privacy? What can their expectations be? I think one can never give up on that. It's a fundamental right, and I think we need to remind people that their privacy is not transactional or commercial. It can't be sold. It's a fundamental right. It defines us as individuals. And it's at the basis of other rights, and that allows us to have a democratic system. It's so important, and we need to remind people of that importance and remind institutions of it as well. And it's not saying that there won't be innovation. It is a fundamental right, but we need to support innovation and public interest. Sometimes it requires more work. But it's the same with equality. It requires work, but it requires less work if we do it from the start. So you need to think about things from the start. So we have to tell people the toothpaste is not completely out of the tube, and if some of it is out of the tube, we'll put it back in the tube because it's important. And by working together, we'll be able to do it. Thank you, Monsieur Villemur and Monsieur Dufresne. Welcome to Monsieur Boulris. Welcome to our committee. You have the floor, and you have 6 minutes. Thank you very much, Monsieur Chair, and thank you, Monsieur Dufresne, for being with us today for this important study. I learned something recently that I found interesting, because you said that legislation will never be modified as quickly as technology evolves. The Department of Justice 2 years ago carried out consultations on privacy legislation, but it wasn't majorly updated and hasn't been updated since '83. I was 10 years old. We were still using floppy disks, and I still had VHS cassettes to watch movies at home. How urgent is it to modernize the Privacy Act? I believe that we need to modernize it. And for the privacy sector as well, that one's 20 years old. It's older than Facebook and social media. It's good to have C27 to modernize legislation for the private sector. I'm eager for it to move forward, and I hope that a bill to modernize the public sector legislation will follow soon after. The Justice Minister said with C27 that there would be such a bill afterwards. Consultations were done with First Nations and Indigenous people for certain impacts. I believe that the results were published in September, not long ago. So the work is ongoing, and I believe that the solution would be to move forward with C27, and the model that will be used there, if it needs to be the same for the public sector, could be a positive thing. We're seeing partnerships between the public and the private sector. Government will be working with industry hand in hand. And with two legislations having different requirements, that's not optimal. It creates interoperability issues. But I agree with you that modernization is important. In the meantime, the legislation is there. We will continue to implement it as best we can at the office. And this is something that I shared with other commissioners in Tokyo, G7 members, and we talked about artificial intelligence, and people were sharing their concerns, and we were saying that there needs to be legislation on AI, and there is legislation that exists. And I launched an investigation on ChatGPT so that we could see whether or not it was compliant. But yes, legislation does need to be modernized. Thank you. You can also make recommendations, but you can't make orders. Do you believe that you should be able to do so? And what would be the advantages? It's very important to be able to give orders. Hopefully we wouldn't have to use it, but the fact that that would exist would incite better decision making. When there are a lot of priorities and a lot of pressures and few resources, well, organizations are going to focus on legal binding obligations. And so I don't want privacy to be treated like something that's just nice to have. But that said, often organizations will do it. I will use my power to make recommendations, but to have an order-making power, that would be very important. In your report, Protecting Privacy During the Pandemic, you mentioned that 3 departments refused to implement your recommendations: National Defense, CBSA, and 1 more. Did they justify the decision to not apply your recommendations? In such talks, and in the cases that you mentioned, sometimes a department will say, well, we believe that what you're recommending is something that we're already doing, or during the pandemic, there was an assessment on proportionality and necessity, and it's not mandatory with the current legislation, but we believe that it should be. So it's a dialogue. We're always given a reason. Sometimes the issues are more serious than others. If there's a situation where there was significant impact and there's a full refusal to follow the order, well, that would undermine trust. And so an order-making power would be very important. Even when we're making a recommendation where an institution will say, thank you, but we're not going to act on your recommendations, I think that we need to have a way to remedy that. And it wouldn't be an issue if we had order-making power. We would use that power if needed. But it needs to be an exception. And same thing with a fine. In the privacy legislation, we would add the ability to give fines to organizations. I think that's important for the same reason as having incentives. Thank you, Monsieur Dufresne and Monsieur Boulris. That is the end of our first round. We're going to start our second round with 5 minutes. Monsieur Gould, you have the floor. Thank you, Mr. Chair. Thank you, Monsieur Dufresne, for being with us. Earlier in your opening remarks, you talked about the provinces and Quebec implemented Bill 25 for privacy. Is it stronger than the federal legislation, or have you worked with your Quebec counterparts? The answer is yes. Bill 25 is stronger than the current federal legislation because it gives order-making power to the office, and they can impose fines, and that reflects the European model for protecting data. And so, yes, it is stronger. There are proactive obligations, and I'm hoping to see that move forward and help modernize the federal legislation. It's not going to be identical, of course, but order-making powers, fines, proactive obligations for businesses, those are all very important. It's a good model to follow. It's a Quebec model, and it's similar to the European model, and it's something that we could have at the federal level. For collaboration with the Quebec office, yes, we work very closely with them and with all provinces and territories, in fact. In September, I was at Quebec City for the yearly meeting of privacy commissioners, and we had very important discussions. We heard 2 talks on youth privacy, and all commissioners agreed. We don't all have the same legislation, but we want people to understand, and we have common investigations with Quebec, Alberta, and BC. We have that with TikTok and ChatGPT, and for Tim Hortons. This collaboration is very useful, and it allows us to be on the same wavelength. Our federal agencies subject to that in Quebec, it applies everywhere in Canada except in provinces where they have a similar legislation to the federal legislation, which is the case in Quebec. So for things that happen only in Quebec, they will fall under the Quebec legislation, but there are a lot of files that go outside of Quebec, for example, internet, social media, and that's why we're working very closely, and we will lead joint investigations to cover everything. I only have 2 minutes left, so people are concerned. We're talking about protecting privacy, and here's an example. I was talking with my spouse about a vacation, and then all of a sudden I'm seeing ads for vacations, and I didn't look anything up. It's like my voice was picked up by the phone and AI, and I'll talk to my son about trucks, and then all of a sudden I'm seeing ads for trucks. That's why it's important to have more transparency and to have proactive obligations so that organizations state, this is why we're using your data, and people should be able to ask questions. Why did I see this ad? And one thing that you're reminding me of, Mr. Gould, is that it's not because information is public and it's available on the internet that it's not protected. I think that people don't always understand that. Sometimes we're saying it's not public, it's on the internet. It's not private, it's on the internet, but that's not the case. There is an exception. It needs to be defined. But in general, you are protected. It seems like a fine line for profiling if it's legal or not legal. For profiling, we want that to be included. If algorithms are being used, if inferences are being made with your personal information and it's used for profiling, that's something that needs to be considered and regulated. The Quebec legislation includes the word profiling, and so does the European model. We recommended that it be explicitly included in C25. Thank you, Mr. Gould, Mr. Dufresne, Mr. Baines.
Thank you, Mr. Chair, and thank you, Mr. Dufresne and Mr. McGuire, for joining us today. Mr. Dufresne, in May 2023, your office announced that it's appealing the federal court's decision regarding Facebook's possible contravention of PIPEDA, noting that issues at the heart of the case are directly related to fundamental privacy rights of Canadians, and that the issues would benefit from being clarified by the Federal Court of Appeal. Has there been any progress there?
There has been progress, so it is making its way through the Federal Court of Appeal process. So we have filed our factum, so our written representations to the Federal Court of Appeal. Facebook has filed its written representation, and so next steps will be to wait for the court to set a hearing date, which we hope to take place in the coming months, and following that, oral arguments and then a decision.
Okay, and your annual report notes that Office of Privacy Commissioner has developed various strategies to promote efficiency gains, which include exploring options for automation to help staff work more efficiently. Have any of the office processes been automated?
We've not automated processes. I'm looking to my colleague, Mr. McGuire. We've been looking at a first step in terms of systems efficiencies, in terms of risk management profiles, in terms of we've developed a tool that to identify a real risk of significant harm in the case of breaches. So that's an automated process. We're obviously monitoring carefully AI and generative AI. We did make the decision that for the moment, because we are investigating ChatGPT, and hoping to conclude that investigation in the coming months. We are not using that tool at the OPC for the moment, but we will be considering, obviously, appropriate uses of any tools that could assist, again, making sure that they are privacy compliant.
And considering you've already stated that ChatGPT is at risk, you're studying that now, and there's so many different versions of that, the ChatGPT or other ones, other AI like it. Are you looking at any others?
Well, for the moment, we are investigating OpenAI and ChatGPT. But again, when we do these investigations, we try to, if we identify lessons or principles, hopefully they can assist and they can guide other organizations. So that was something, for instance, in the Home Depot decision. We made our conclusions specific to Home Depot, but this was a practice that was being used in the industry. And so when I made my report public, I called on other organizations, any organizations who would be using a similar practice of sharing information when Canadians ask for an email receipt instead of a printed receipt. I said, this is against privacy law. It needs to stop. And a number of organizations were identified as having that practice. We reached out to them, and a great many if not all, have stopped. So that is a systemic impact that we look to have as well, even if we're dealing with one specific case.
You mentioned working with Quebec and others. There's a global privacy assembly, and can you maybe elaborate on how participating in those international bodies improves?
Certainly, and we talk about, thank you for the question, we talk about that in the annual report. There is a very strong, active domestic Canadian community, federal, provincial, territorial, but also international. So there's a number of groups. I've been very active with the G7 roundtable of data protection authorities. Data protection authority are essentially privacy commissioners from the G7 countries. We meet annually. We met a year and a half ago in Bonn, Germany. This year we met in Tokyo. And some of the key themes of that group have been cross-border data flows, ensuring that we can have strong international trade. When data is traveling from jurisdiction to jurisdiction, how do you ensure that it is protected and safe? And so there are a number of tools, legislative, contractual programs, and so on. So we have discussions on that. And AI has been a growing topic. We issued a statement last June in Tokyo about our expectations. I think it was one of the first statements in terms of privacy commissioners setting out from a privacy perspective, these are our expectations for AI. And so we said, one, current laws apply. So privacy law applies. It's not a legal void. We already have protections. We're going to apply them. And also we said our expectations of organizations is that they have privacy by design, that they have privacy impact assessments when developing these tools, and that they do this. So it was a call to action. I was happy to see that in industry department's voluntary code of practice for AI that was launched a couple of weeks ago, that G7 declaration was highlighted as was a reminder that Privacy Act continues to be important.
Wonderful. Thank you, Mr. Dufresne. Mr. Baines, Monsieur Villemure, 2 minutes et demie, s'il vous plaît.
Merci beaucoup, Monsieur le Président. J'aimerais
Thank you very much. I would like to table a notice of motion that pursuant to Standing Order 1083H, the committee undertake a study of the RCMP's decision not to launch a criminal investigation against Prime Minister Justin Trudeau following the reprimand issued by the Conflict of Interest and Ethics Commissioner regarding his involvement in the SNC-Lavalin affair. That the committee devote 3 meetings to this study. That the committee invite to testify for 1 hour per witness A. The former Conflict of Interest and Ethics Commissioner, Mr. Mario Dion. B. The acting Conflict of Interest and Ethics Commissioner, Mr. Conrad von Finkenstein. C. The RCMP Commissioner, Mr. Michael Duhem. D. Mr. Frédéric Pincin, International and Sensitive Investigations Federal Police Ontario Division. E. Royal Canadian Mounted Police Representatives in 2019, and the former advisor to the Prime Minister, Mr. Gerald Butts. That the committee report to the House, and that pursuant to Standing Order 109, the committee requests a comprehensive response from the government. Thank you very much, Mr. Villemure.
Motion on notice that you're placing,
Oui,
correct?
absolument.
Okay. So, j'ai arrêté ta temps. J'ai 2...
I had stopped your time. You have 2 minutes and 26 seconds. Do you have questions to ask of the witness? Yes. Go ahead. Thank you. Apologies, Mr. Commissioner. Earlier you talked about something that brought up some memories. You said that if information is on the internet, it is not necessarily public. And I would like for you to explain, because I don't think everybody understands that. So, privacy legislation applies to personal information and identifiable information because it needs to be protected. There are many inferences that can be made from that information. And there is an exception in the legislation that states public information will not be targeted by certain obligations, but the exception is very narrow and very limited. Generally, information that is on the internet, if it's public, if it's personal information, it stays personal information. And so it is subject to legislation. Organizations, companies cannot use that information as they will. They need to follow the rules. That is why we had investigations on organizations that were taking photos for facial recognition and trying to sell that to police organizations. We investigated Clearview AI, and we realized that their database was going way too deep. There were no limits. Nothing had been defined. And we sent a special report to Parliament, so on the use by the RCMP of that company, and we stated that the RCMP should not have used that company that was not respecting its obligations. And the RCMP stopped using it and created a program to assess new technologies. So that's an example of how it might be on the internet, but it's still protected. Thank you, that's very interesting. The new word of the week that we heard is called spamouflage. And when we talk about that, what are your concerns? A quick answer, please. A quick answer, please. I think that the concern is that if we're giving false information and we're misleading Canadians with information that looks real but is actually fake, this is a concern on AI and generative AI. There is an OECD report that surveyed G7 ministers, and the main concern on AI was misinformation and disinformation. The third thing was privacy, and so it shows the importance of protecting privacy and to protect against disinformation. The report is publicly available. Thank you, Monsieur Dufresne and Monsieur Villemure. Monsieur Boulris, you have 2.5 minutes, please. Thank you very much, Mr. Chair. Monsieur Dufresne, at the end of my previous round of questions, you talked about the importance of proportionality principles, and you said that your office applies them. But in the report during the pandemic, you stated that the current legislation is too weak. And so, if you could explain what that means and what is the difference? What is the difference between the current legislation and what you would propose? In the Privacy Act for the public sector, the obligation is lower than for the private sector. So the government and departments need to state that the data was used following the mandate. There are certain obligations that are more specific. For example, what was used in Canada Post when they were using indirect information, and they needed to seek authorization. But the main principle when it's a public institution is to say, is it linked to the mandate of the organization? We say that according to international principles and to what's being done on the private market, we should implement that proportionality and necessity. Why are you getting that data? What do you need it for? It's the same when we're talking about human rights. Is the goal important enough? Will the measures that you're taking help you reach that goal? And are you doing everything that you can to limit the use of the information to meet your goals? These are all things that we highlighted in our report on the pandemic. And we gave recommendations. And in general, the government complied with those. And we stated that sometimes there could have been more information given on the options that you rejected. This allows decision makers to say, this is what I'm doing. Am I limiting risk? It's similar to one of my recommendations on C27. There needs to be obligations for privacy risk assessments. So we look at PIAs and what are the tools for minimizing risk. That's good for Canadians. Thank you, Monsieur Dufresne and Monsieur Boulris. We have two more questions left. Ms. Gladue for 5 minutes and Mr. Callaway for 5 minutes. Ms. Gladue, you have 5 minutes, please.
Chair, and thank you to Mr. Dufresne and Mr. McGuire for being here tonight. I want to start off, I'm very disappointed that Canada Post was taking people's private information and selling it to others, and even more disappointed that when you pointed it out and asked them to stop, that they didn't really do anything until it went public, and now they're just reviewing it. Is there no remedy that you or the federal government could do to make Canada Post stop taking people's private information and selling it?
Well, this is why I've recommended to have the authority to issue binding orders, which I do not have under the private sector, either private sector or public sector. And so what I do have is the authority to make recommendations and to make those recommendations public. So this is what I have used. I was pleased to see the response from the public and parliamentarians. There was a question on the order paper that was tabled. There was a statement from Minister Duclos indicating that he had called the CEO and President CEO of Canada Post, that he had reiterated that the protection and preservation of Canadians' right to privacy is of utmost importance. And following that, the Canada Post issued a statement indicating that they would conduct a review of their services program to ensure that they live up to the standards that Canadians expect. But that's all I've had.
That's good. I mean, I hope that they do take action on that. And I think when we looked at the Official Languages Act, the Commissioner of the Official Languages needed more powers to enforce as well. So I think that's a good point to take forward. I want to follow up on your discussion about the pandemic and some privacy issues there. I mean, obviously, my employer can't share my vaccination status, and my doctor can't share my vaccination status, but during the pandemic, every bar and restaurant had a list of everybody that was there and whether or not they were vaccinated. And I thought that was a violation of PIPEDA. Did you comment about this at all in your recommendations?
We made some overall recommendations, mostly towards the public sector. Now, my colleague, this was before my arrival, but certainly there were recommendations in terms of necessity and proportionality, in terms of time limiting, in terms of making sure that you were documenting and data minimizing. And in the context of our report, we looked at the government's approaches in that sphere, and we applied the necessity and proportionality and made some conclusions there.
And were there recommendations of what to do differently in the future?
There were some recommendations, certainly in terms of so there was one breach in the context of ArriveCAN. So we made some recommendations there in terms of stronger safety measures in terms of this type of information and making it avoiding errors. This was a situation where there's an error. People were told that they need to isolate it when they didn't. Making sure that you maintain good information and that you get rid of bad information. We made some recommendations sometimes in terms of the objectives. There were some debates sometimes about what was the objective in this case. Was it to increase vaccination, or was it public health, or was it both? So there were some recommendations there, and there were some recommendations in terms of documenting and keeping the information about what other options did you consider? So they were really in terms of that discipline of the process.
Very good, thank you. I want to turn my attention to the digital technology in C27. One of the concerns that's been raised as a gap is people are worried about deep fakes. You know, this generative AI that will make anybody look like they're saying or doing things that they actually didn't. Did you provide any recommendations to the minister, or do you have any thoughts on how to fix that?
I think the recommendation we made on that, well, there's three that we made on specifically to AI that would both help that issue. One was mandating privacy impact assessments whenever you have a high impact system of AI, and that would be one. And so doing that, you would need as an organization to say, what's the risk? What's the privacy risk? What is the risk of these types of deepfakes? How are you mitigating that? And there are some proposed provisions in the ADA, Artificial Intelligence Data Act, that would do that as well. We recommended great transparency for AI decisions. So if a decision is made about you, you can ask an explanation. So if you see something that's strange, you see a video of you, ask that question, you get that explanation. And we also recommended collaboration between regulators. Now, we do that where we can. I've just launched with the Competition Bureau CRTC chair a digital regulators forum. But there are limits on what we can do. We can't collaborate in investigations, for example. I can do that with the FTC in the US and other countries, but I can't do it in Canada. So that's a gap that would be easily fixed. In my view, it should be fixed.
Thank you, Mr. Dufresne. Thank you, Madame Gladue. Mr. Kellaway, 5 minutes. Go ahead, please.
Thank you, Mr. Chair. And normally I'm on Fisheries Committee, so it's a nice change. And obviously the work we do here is very, very critical. And I have a couple of questions. One was around when TikTok was here, they appeared to be concerned about the government banning their app on government devices. The decision to do that, was it the right one, wrong one? Can you unpack that for me?
Well, that was a decision that was made by the Government of Canada. The Government of Canada made decisions based on its review, based on the expert assessment of the Chief Information Officer and experts, and they made that on the basis of privacy, security considerations. And so they would be better placed than I would be in discussing this. What I have done is I have initiated a complaint with my colleagues in Quebec, BC, Alberta, to look at TikTok's practices in terms of data protection and use, particularly with respect to children. So they're different issues. There may be some overlap in certain areas, but they're two separate decisions.
Overlaps are.
Well, to the extent that there are privacy concerns from the government in making its decision, and there were some stated privacy concerns, so there may be some overlaps there. But I'm not involved in that assessment from the government side. But my focus in the investigation will be to look at the data practices, the consent, appropriate purposes, and with a particular focus on children and youth because they are a majority of
vulnerable,
users.
yeah. Mr. McGuire, do you have any thoughts on that?
I don't think I'd add anything. No.
Okay. No, thanks for that. So I know this is going to surprise both of you. I'm not a techie. I use Facebook. I use TikTok. I use Twitter. But for the parents at home or people at home, Mr. Vilmer talked about is the toothpaste out of the container, as it were. And I'm wondering, is there any advice that you could give people that are watching this that may watch it later in terms of how best to protect their privacy based on the work you've done?
I would say a few things. And one, we've issued a declaration with my federal, provincial, territorial colleagues called Putting the Best Interests of Young People at the Forefront of Privacy and Access to Personal Information. It's available on our website. And we give a number of recommendations, expectations for organizations about making sure that you're protecting children and the best interest of the child and that you're treating the information appropriately. In terms of what people should do, and that's something we've said in our data scraping statement with my international colleagues, is ask yourself, are you comfortable sharing this much information? Do you know enough about the settings and the protections that are there? Is this something that you want to see potentially forever? Now, we're working in C27. There's a new proposed section to dispose of information, and especially for minors. So that's good. But whatever you're putting a picture of your children online, ask yourself, is this? Do you want to take the risk have you put the privacy settings in a strong enough way? Are you sharing this with the whole world? And if you don't understand enough about what the organization is doing, and you find that their privacy policy is complex, I always encourage everyone, ask the organization. Ask for more information. Right. When stores ask for your birthday, ask them why they want to know your birthday when you're buying jewelry or any kind of item. Why did they need that information? So getting that reflex of not just saying, yes, sure, I'll give it to you.
Yeah. Mr. Chair, how much time do I have?
It's 50 seconds.
50 seconds. Okay. I think you touched upon this to some degree, but can you speak to maybe a little bit more detail in the time that we have in terms of the collaboration, the coordination that goes on with the other regulatory bodies, but in particular law enforcement?
Well, we have exchanges with other regulators, Competition Bureau, CRTC. We've launched this new Digital Regulators Forum, and the goal is to talk about areas of common interest with privacy components. Law enforcement, also, we have exchanges with the RCMP to discuss issues of new technology, to provide our input. We have a government advisory section, so we're always engaged in these types of...
Are local police involved in that, in the RCPS, but do we deal with the other
I think
municipal...
it's been mostly with RCMP, but perhaps...
Okay.
Local police would fall under provincial jurisdiction.
Yeah, correct. Thank you so much.
Thank you, Mr. Kellaway. Always solid, Mr. Dufresne. Appreciate that. That concludes our first hour. What I'd like to do is roll right into the next hour. Give Mr. Dufresne a second to get his notes together. But I do want to make the committee aware that I did have a request from TikTok to extend by a week their requirement to provide us with written responses to the written questions. They've asked that, if the committee recalls, it was supposed to be this Friday. They've asked until next Friday. So with the committee's consent, I'd like to give them that extension so that we get the answers that we need. Is that okay? Good. Monsieur Boulris, Lapousse, there you go. Okay, so we're going to, we had a lot of sort of crosstalk there about TikTok, and so we're going to move into our second hour, which is our social media study, focus on TikTok. Mr. Dufresne, if you'd like to address the committee for 5 minutes, I'd appreciate that, and then we'll get into questioning. Thank you. Go ahead, please.
Thank you, Mr. Chair. I'm pleased to now turn to this part of the discussion and thank the committee for your interest in the ways that social media platforms such as TikTok harvest, handle, and share personal information. The online world brings with it a host of possibilities for innovation and connection, but it also carries potential for significant harm, especially for young people. As you know, my office, along with our counterparts in Quebec, British Columbia, and Alberta, launched an investigation into TikTok in February. We are examining whether TikTok's practices comply with Canadian privacy legislation, and in particular, whether it obtains valid and meaningful consent for the collection, use, and disclosure of personal information. We are also looking at whether a reasonable person would consider the purposes for which it handles personal information, in particular children's information, to be appropriate in the circumstances. Il s'agit d'une grande priorité pour le commissariat.
This matter is a high priority for my office, especially given the importance of protecting the fundamental right to privacy of young people, who represent a notable proportion of TikTok users. As a result of the ongoing investigation, there are limits to my ability to speak publicly about the company's practices at the moment. For that reason, I will focus my remarks today on the privacy principles that underpin my office's approach to the digital world from the perspective of the privacy rights of children. Growing up in the digital age presents significant new challenges for the privacy of young people. As children and youth embrace new technologies and experience much of their lives online, we need strong safeguards to protect their personal information and how it may be collected, used, and disclosed. Increasingly, their information is being used to create personalized content and advertising profiles that are ultimately aimed at influencing their behaviors.
The right to be children, even in the digital world. As UNICEF notes in its policy guidance on artificial intelligence for children, young people are affected by digital technologies to a greater extent than adults. Young people are also less able to understand and appreciate the long-term implications of consenting to their data collection. Privacy laws should recognize the rights of the child and the right to be a child. This means interpreting the privacy provisions in the legislation in a way that is consistent with the best interest of the child. I am encouraged by statements from the Minister of Innovation, Science and Industry indicating that there is a desire to strengthen children's privacy rights in Bill C-27, the Digital Charter Implementation Act 2022. My office has recommended that a preamble of a modernized federal privacy law should recognize that the processing of personal data should respect children's privacy and the best interest of the child. I believe that this would encourage organizations to build privacy for children into their products and services by design and by default. And I was pleased to hear the Minister signaling his agreement with that recommendation. La loi doit prévoir des mesures de protection solides en vue de protéger les renseignements.
The law must have strong safeguards to protect children's information from unauthorized access and reflect greater consideration of the appropriateness of collecting, using, and disclosing their information. Earlier this month, my provincial and territorial colleagues and I adopted a resolution calling on organizations in the private and public sectors to put the best interests of young people first by, among other things, providing privacy tools and consent mechanisms that are appropriate for young people and their maturity level, rejecting the kind of deceptive practices that influence young people to make poor privacy decisions or to engage in harmful behaviors, and allowing for the deletion and de-indexing of information that was collected when users were children, something that I am happy to see was included in Bill C-27.
That government and organizations take action to ensure that young people can benefit from technology and be active online without the risk of being targeted, manipulated, or harmed as a result. I expect that the findings from our investigation into TikTok will be informative not just for that company, but also for other organizations that collect and handle children's sensitive personal information. I also look forward to seeing Bill C-27 progress through the legislative process in a way that will provide children and minors with the privacy protections that they need in this increasingly digital world. With that, I will be happy to take your questions.
Thank you, Mr. Dufresne. Mr. Barrett, 6 minutes. Go ahead, please.
Thanks, Chair. Thanks very much for continuing your appearance with the committee. Can you give us more detail about the scope of the investigation, the complaint that you've initiated against TikTok or concerning the issue of TikTok?
Sure. So when we announced the investigation on February 23rd, 2023, we indicated that this was initiated in the wake of now settled class action lawsuits in the U.S. and Canada, as well as numerous media reports related to TikTok's collection, use, and disclosure of personal information. we indicated that the 4 privacy regulators will examine whether the organization's practices are in compliance with Canadian privacy legislation, and in particular, whether valid and meaningful consent is being obtained for the collection, use, and disclosure of personal information. The investigation will also determine if the company is meeting its transparency obligations, particularly when collecting personal information from its users. And we added that an important proportion of TikTok users are younger users, and that given the importance of protecting children's privacy, the joint investigation will have a particular focus on TikTok's privacy practices as they relate to younger users, including whether the company obtained valid and meaningful consent for these users for the collection, use, and disclosure of their personal information. In the course of the investigation, we've now added an element of reviewing whether this was done for appropriate purposes, which is another element of the Act. And so that's now being added to those elements under review.
Has TikTok been cooperating with your investigation and the inquiries that you've made?
I'll look to Mr. McGuire. My sense is that
They have been cooperative. Yeah.
And does your investigation extend or have any reach to their parent company, ByteDance?
The investigation involves ByteDance as the owner of TikTok.
With respect to the national intelligence law passed by the CCP in 2017 that requires any organization to assist or cooperate with state intelligence work, on top of a 2014 law that says relevant organizations may not refuse to collect evidence for an investigation, does that cause concern? And what are you able to, what assurances are you able to extract from ByteDance that their responsibilities to the communist dictatorship in Beijing aren't going to supersede the privacy requirements here in Canada?
So we are focusing on the data practices, again, specifically with respect to children's information. And so looking at the safeguards, looking at the tools, looking at the rules. There is a provision under PIPEDA that talks about an organization being responsible for information in its custody, including information that has been transferred to a third party for processing. They shall use contractual or other means to provide a comparable level of protection while the information is being processed by a third party. But the focus of the investigation here very much is in terms of what is ByteDance doing with the information of children.
Did you watch the testimony from the representatives from TikTok at this committee last week?
I've reviewed the transcript.
And is all of the information that was provided in their testimony consistent with the evidence that you've reviewed as part of the complaint that you've undertaken?
I've not looked at it from that standpoint. As I said, the investigation is ongoing. We have not made our findings. We have not drawn our conclusions. So I wouldn't be in a position of drawing conclusions at this stage on this point.
Do you know where the information where Canadian user information for TikTok is stored? Do you know where those servers are?
I think in the testimony of the TikTok witnesses, they mentioned Singapore, if I remember the transcript that I've seen.
And
U.S.
I'll simply add that we in the context of an investigation, we wouldn't be able to share information that's been provided to us in the investigation at this time. We have the ability to publish a report of findings when we're completed our investigation, and would share further information that we obtained during it.
What is the scope or what type of recommendations would you make to Canadians in following following a report into a platform like this? Can you take us through what your recommendations might look like? You've talked about your recommendations to the entity, but what about to the Canadian public? So it's one thing for you to tell Acme Co. You ought to do this. But what about telling the Canadian public about what they ought to be doing when interacting with a platform where you may or may not identify concerns?
Certainly will.
Got to keep
I
it
can,
tight, 30 seconds.
Sure.
please.
Well, I'll give you an example of what we did with the Home Depot, for instance. When we made that investigation public, we talked about the recommendations we made to Home Depot. But in doing that, and I don't recall if it was in the report of findings itself or in my statement, gave advice to Canadians. But always saying that ultimately, I don't want it to be delegated to Canadians to protect their privacy. It's the obligation is on organizations. But they are good tools and practices, and we would certainly take that opportunity.
Would you go as far as to tell Canadian consumers, Canadians, to not use a service or to not use an app or to not provide their information to a business?
Very quick.
I don't want to speculate as to what we would say, but we would consider appropriate advice to Canadians in the
Thank you, Mr.
circumstances.
Barrett. Thank you, Mr. Barrett. Ms. Khalid, 6 minutes. Go ahead, please.
Very much. Thank you very much, Mr. Chair, and thank you to our witnesses for appearing today on a double shift with two different issues. We really appreciate it. I just want to pick up on something that you had said with respect to your study and your report based on children and with TikTok. How much of a distinction is it, and when we are talking about privacy rights specifically for children, or at large the general public? Is there a significant overlap, or are there extra issues that we deal with for minors as well, for children?
Well, there are extra issues in the sense that we will generally consider minors' information or children's information to be sensitive information, and that brings with it greater obligations in terms of care, in terms of methods of consent. We've issued guidance under current law about obtaining meaningful consent and what we are expecting organization, making it user-friendly and so on, but specifically with respect to children, there are circumstances where they won't be able to give that consent. They may need a parent to do that. If they're below a certain age, in our current guidance, we said it might depend. Certain provinces might take different views, but for us, if it's less than 13 years old, there's almost a presumption that you need that. So it certainly is something that has to be considered in how you look at information, because they will have different needs. They will have greater vulnerabilities, and that's something that's recognized in the European legislation. It's something that is proposed to being recognized in C27. Certainly, something that I hope to see will happen.
You talked about meaningful consent. What does that look like in the context of social media platforms that have so much access to information of Canadians?
Meaningful consent, and again, this is something where C27 will make it stronger in terms of explicitly saying this has to be provided in an information that the person can understand. So that's what we look at. We look at this is very complex information. How are you giving those notices? Are you giving a notice that only an expert's going to understand? And even if you're an expert, you may be reviewing this at the end of the day. You may be tired. You're bombarded with so many things. Every time you go on a website, you get a cookie page or whatnot. So we provide a number of tips in that guidance in terms of make it user-friendly. Make it not just a one-time thing. Make sure that sometimes you provide follow-ups, or you make it as understandable as possible. In the context of children, make it appropriate to the child. Maybe there's opportunities for a video or another way, but the goal is provide the information so the individuals can understand what is going on and bring that same innovation. We often talk about innovation requiring data, and that's true. But let's use innovation to protect data, and that would assist in terms of the consent and the explainability.
How does that protection of data play out when we see that a company like TikTok is storing data in the U.S., in Singapore, in Malaysia, and not in Canada? How do we control the servers or the access to Canadian data when it's physically not present in Canada?
Right. Well, the law will still apply if there are Canadians that are affected. So there are a number of factors that will give us jurisdiction, even if the information itself may be stored elsewhere. And so that we look at those factors, those links, and then we apply the law to the organization and to the treatment of the information at issue.
Thank you. And so when we had TikTok representatives here with us, David Lieber, who appeared at the last meeting, said, "We also have a biannual transparency report where we disclose a number of government requests that we receive from governments throughout the world. If we did receive a request from the Chinese government, we would certainly disclose it in our transparency report. Now, have you looked at these transparency reports? What kind of details do they provide, and are they actually transparent?
In preparing for this appearance, I was briefed on these types of reports, and I think the question to be considered there is what is the extent? If you're pointing to a report to say, well, this report will give transparency, I haven't looked at that specific report, but I would say, what is the report about, and what will it report on? Will it report only on Canadian government request? Will it report on governments all over the world? So that's an important element to make sure.
Well, I would assume that, especially with data not being stored physically in Canada, that if there's a request made by XYZ state or country to say, hey, TikTok, can you give us all of the data on every 16-year-old girl who likes MAC lipstick? Should TikTok have a duty to report that to Canadian authorities, that request of information by a country that is not Canada?
This is not something that we've investigated or turned our mind on, but I generally say that if we look at a matter, the protection of information, we're going to look at the safeguards, we're going to look at what are the risks, we're going to look at what are the measures that you're putting in place to protect that information, and based on that, we'll make our recommendations and our findings.
And do you find that companies like TikTok and other social media platforms would heed some of your recommendations, or how do you anticipate that some of your recommendations would be applied within Canada and in terms of privacy?
Well,
very quickly.
Well, this is where order-making power is an important element. Right now, we would make recommendation. It's up to them to decide if they're going to follow up. If there's order-making power, that can be enforced.
Okay. Thank you, Ms. Khalid. Monsieur Villemure, 6 minutes.
Monsieur Villemure, you have 6 minutes. Monsieur Dufresne, how would you define their appetite for protecting privacy? I would say that the different platforms participate in privacy conferences. They're very interested in the matter. We look at what's being done. How are these platforms using the information? And so we'll make recommendations. We made recommendations on data scraping and getting information on the internet. And we said to the different platforms, we're expecting more from you. We're expecting you to be more proactive and that you protect this data. And so we received comments from them on our declaration, and we discussed it with them. And we're before the courts with Facebook and Cambridge Analytica, and we're currently investigating TikTok and ChatGPT. And the process exists, and it's not the intentions and the affirmations. We want to see what the results are, what the impact is. Do you believe that every time you make a step forward for protecting privacy, that platforms are trying to find a way to circumvent the measures to protect their market, which is selling data? I think that there's often an economic incentive to use information, and so organizations are receiving that incentive. It's part of the economic system. And so governments and regulation organizations need to make incentives to protect information. There could be a positive incentive saying we will recognize good behavior, but there also needs to be a legal consequence. And so we need to tell them you need to publish your privacy plan, you need to carry out assessments, you need to limit the use of data and explain your use of data. And if you don't do that, there can be investigations orders, fines, it takes all of that. Do you think that your power can dissuade platforms enough, or do you find that you don't have the tools other than orders? I think that for now I'm missing order-making powers and fines, because when we're talking about incentives, well, an organization can make millions, tens of millions by using data, and if there are no fines for violating regulations, well, then it might be tempting for them. So for companies that are making millions or billions, and for TikTok, they were fined by Europe, and when a company is making billions of dollars, what could a fine be? What does it even mean for them? So that's why the European model and the Quebec model say, well, it'll be a maximum of $10 million or 3% of earnings. I think that that would solve the issue that you've raised. The European example shows that that percentage works. And what do you think about TikTok being banned in certain countries? I think that governments need to do their work and ensure that there's compliance, and they also have responsibilities for national security and protecting public servants, and that's what the government here did. We're talking about public servants' work tools that contain sensitive information, and that's part of government's responsibilities. You talked about national security. We think about TikTok as being a fun tool and not having an international impact. But last week we asked TikTok if they sell data to their company. They said that they share that information. But what do you think of that sharing of information? Whether they're being paid or not, it's an issue. There should be limits to what can be done in collecting data and sharing data. And that company, ByteDance, is known for being part of the communist regime. It is part of the context that needs to be considered. When we're talking about data sharing, we need to see if it's appropriate. Does it respect the legislation? Does it raise privacy concerns? It would be good for those companies to make things public, to say there are institutions that do their work correctly. Thank you very much. Monsieur Boulris, you have 6 minutes. Thank you very much, Mr. Chair. Thank you, Monsieur Dufresne, for being with us. I'll take a quick step back. In the last century, when people bought a newspaper in the morning, it was very different from the apps that we have now. And it helped people purchase products of companies that were putting ads in their newspapers. But a company that was purchasing ads in the newspaper, they didn't know who was reading the newspaper and who might be purchasing their product. But now with social media, the dynamic is completely different. People will almost voluntarily give their information to these big companies that will sell or share that information so that enormous profits can be made. So Canadians or citizens are freely providing information that will allow these companies to make micro-targeted ads and allow them to have significant profits. You talked about reflexes earlier, and do you believe that most people understand that they're giving up their data for free? There is an expression that says, if it's free, you're the product. And that's exactly what you're describing. And we need to be aware of that. When you're asked what your birthday is, when you're purchasing a product and you're told, well, it's because you'll get a discount on your birthday, well, that's what they're doing. They're paying us by giving us a discount in order to use that information. So people might think that it's free, but you're giving away an essential piece of your personality away. And so people need to be aware of this. And it can't be seen as a simple good, because our privacy isn't something that can be sold even if proper consent is given. It's very fundamental to our individuality. But yes, that is very important. Thank you, Monsieur Dufresne. As said Louis-José Hood, I don't need my phone to buy a spatula. But you carried out an investigation on Facebook in 2019, now known as Meta, and you had 4 main conclusions that were quite concerning. Facebook was not receiving meaningful consent of its users. It also was not receiving meaningful consent from the friends of users, and there weren't the safeguards in place to protect users' information, and they were not sufficient. These conclusions are quite concerning because of the popularity of this platform. Since this investigation and these 4 conclusions, what has changed? The legislation doesn't give us order-making power, but it allows us to go to the federal court and to bring our case there and to ask for the order that we would have wanted to give. And that is what was done. The federal court rejected our request and concluded that the request was not established, and so we appealed the decision on the basis of the different levels of consent and security measures. I announced that appeal, saying that these are important questions for Canadians, and we weren't satisfied by the federal court's decision, and we wanted the Federal Court of Appeal to make a decision. And so we are currently waiting to plead our case, and then we'll have a decision. According to your knowledge and understanding, the conclusions that you came to with Facebook, would they be an exception in social media, or would Facebook and Meta be pretty representative of these big social media platforms? I don't want to make a generalization because this is a specific case before the courts, but I can say that when we can make larger conclusions, we do so, and I expect that the different social media companies be aware of our decisions. I always tell them to look at their practices, and if they're similar, well, then they need to rectify the matter. Thank you, Mr. Boulris and Mr. Dufresne.
Next round, I have had a request, as I mentioned at the onset of this particular round, that there was some discussion about TikTok in the last hour. So the request is, and I want you to consider this, I'm not asking this now, but I will ask at the end of the meeting, to have some of that information extracted and placed into this report that's relevant to our study on TikTok. So I see Mr. Barrett's not here, and I know he stepped out for a sec. That's why I want to just give you a little bit of a notice, okay, to consider that. Ms. Gladue, you have 5 minutes. Go ahead, please.
Chair, and certainly I think that would be a good idea to incorporate that data. So I want to continue on the questions about Meta, because the government made 2,859 requests to Meta between January and June of 2022 to restrict access to content. Do you know if any of those requests were related to concerns about privacy or about where the data might be going?
I'm not aware. I'm not aware of that. I don't have information on that, unfortunately.
Very good. Well, let me go on to TikTok then. So one of the concerns is that ByteDance might be sharing data. And so you're looking into the situation. How would you verify what they say? Like, how are they going to show that they're actually doing the protections that are required by law?
There are a number of tools in the Act in terms of site visits or in terms of requests for documentation. We have a technical lab at the OPC, so we're looking at technical tools to be able to do the investigations and obtain the information that we need. I don't know if Mr. McGuire has anything to add in terms of general investigative tools.
We also have the ability to interview, including under oath, as well as visit the site to require the production of information or documents or things. So we have the ability to not only ask questions, but also to ask those be sworn, and finally to verify through testing, either remotely or on site.
Excellent, very good. What about the concern with cyber breaches? I know you had indicated in the earlier hour that there have been less reported cyber breaches within the government, but there's a suspicion that perhaps there's underreporting. What about the breaches of people's personal data from these various social media platforms? What can you tell us about the situation there?
Well, we've provided statistics in our annual report for both the public sector and the private sector. So in the context of the public sector, the overall comment was we find that the level of reporting is low. So we suspect that it feels like it must be higher than that in reality. So we're curious about that. So we're flagging that. In terms of the private sector, we've seen increases as well in terms of the private sector breaches, and we receive notifications of those breaches, and we are in contact with organizations when they occur. So this is something that is a big focus because of the privacy harm that this could have on Canadians. You have some statistics?
Not statistics, but I would add that what we have seen is examples of scraping of users' data from social media in cases like Clearview AI, Profile Technologies before that, and we found that those to be unauthorized scraping. With our international counterparts, 11 international counterparts from 6 continents, we issued a joint statement on data scraping and directed that to social media companies, asking for them to discuss how they comply with the expectations we identified in that statement. And we continue to engage with those social media companies to get a sense of the best practices and potentially recommendations to improve protection against scraping of information off their platforms.
Excellent. Now, in terms of the complaints that you received, you said your complaints were up 37% overall. And I guess, is there, what percentage of those is related to social media platforms, and has that percentage or distribution changed over time?
I'll ask my colleague for the specific statistics. We have them in the annex of the report, listed by departments in terms of the public sector, and we are listing in terms of,
It's okay. If you want to just make sure you send the reference to the clerk, then they can distribute it. Final question, I'm running out of time. What would you recommend to this committee to recommend to the government to do something to better protect the privacy of Canadians?
In 13 seconds.
well, as legislators, you can do a lot to protect the privacy of Canadians in terms of amending public sector and private sector privacy legislation. Those are really the ultimate first tools that we use to do our job.
Thank you, Mr. Dufresne. Ms. Dama, 5 minutes. Go ahead, please.
Thanks, Chair. Thank you for being here. I remember a number of years ago, someone who had a marketing company was saying that people will give it a lot more of their personal information when they're doing it online versus if they were to actually talk face-to-face to a person. And that's certainly true on social media, too, when you think about the things that you're sharing. Do you think the government should be investing more money in educating Canadians about digital literacy and the privacy concerns that you've expressed? Because I don't think people think about it.
I do. I think that we should do more at all levels. I think this is something that I would want my office to do more. We have a promotion mandate, and we're looking and we're thinking about how we can do that, particularly with respect to children. That was a big part of our internal discussions. I'll be consulting stakeholders as well. I've been having lots of discussions with industry and governments and academia. But how can we reach and do more for Canadians to understand about their privacy? Again, in particular, young children, but not only. And so this resolution that we issued this month with my provincial territorial counterparts, that's one effort that we are doing to say, here are some of the expectations. Here's why you need to protect children's information. Here's how you should do it. But government, absolutely. Schools, teachers, this is a collective effort.
Yeah, I think children in particular, because they're more vulnerable, but I don't think parents think about it when they do let their kids go on to social media platforms. And I know we've talked a lot about TikTok today and kids being vulnerable. Is it just TikTok or is it all social media platforms? And is it a problem for kids because they tend to be the predominant users of TikTok?
Well, it's a problem for kids because of the greater vulnerability. So we've made a number of recommendations in terms of make sure that you're not using these behavioral techniques of nudging. We shouldn't be nudging individuals generally, but certainly not children, in making bad decisions and making bad privacy decisions. So there needs to be work on that. There have been reports on social media being addictive for children generally. And sometimes the business model being that it's going to try to encourage you to stay longer because that's what generates more revenues. And so that is something that has to be taken in consideration with children who have been more and more online, certainly during the pandemic and since with school. I've seen it, parents have seen it. And so we need to adjust to this new reality, parents and children and society as a whole, so that there is a greater awareness of what does this mean? What are your rights? Bill C-27 proposes a right to disposal. So in informing, when I say children have a right to be children, that's what I'm alluding to, is that children do things online. If it stays forever online, well, then they're treated as adults right from when they're teenagers. And it stays forever, and it can be used against them for jobs and so on and so forth. So we need to deal with this. C-27 will deal with it to some extent, but it's certainly something that we need to build greater awareness to say we are living more and more in a digital world, brings great innovation, brings great things, but we need to be well equipped about it. We need to learn about it. So I would hope to see this as mandatory training in schools early on so that individuals get the tools early on. We get these reflexes to say, well, we're going to ask questions. We're going to ask why you need this information. We're going to learn to see what's a good privacy policy. And if it's not, we're going to learn how to complain about it so that it can become a good privacy policy in the future. And that way we're creating ambassadors for privacy everywhere.
When you talk, I know I've only got a minute left or a little less, but when you talk about privacy policies, those things come up as very long, very legalese. Is there not a way that those could be simplified for people before they say accept?
Absolutely, absolutely, and they need to be simplified. They need to be shorter, more concise, and they need to get to the heart of it. So sometimes you have a very long, drawn-out legalistic policy which doesn't really communicate really important things that could be done more shortly. You know, you agree to this, you agree to us sharing it with third parties, including outside of Canada, or you agree to this, we can make inferences about you. We can draw conclusions that go beyond what you're giving us. So you need to know that. We can guess your age. We can guess a number of things about you. So finding that balance in terms of content and concision.
Okay. Thank you, Ms. Damoff. Monsieur Dufresne, la prochaine intervention est pour Monsieur Blanchette Jean Casse. Accueillez le comité, 2 minutes et demie, s'il vous plaît.
Merci beaucoup, Monsieur le Président. Je salue les collègues et les...
Thank you, Mr. Chair. My question is quite simple, but also quite complex. Could you tell us whether or not a revision of the Act is necessary? Yes, for both. One is currently ongoing for the private sector. That's C-27. And there is a component on AI. It's necessary because the Act is 20 years old. It's older than social media. So we're continuing to apply it. The principles are there, but technology is changing rapidly. And so it needs to have more proactive obligations that organizations need to carry out assessments and share this with the office. And for the public sector, it's even older. It's 40 years old. And it needs to be modernized and strengthened because when it was adopted, the impact of data was really not what it is now. You mentioned that social media didn't exist when that legislation was created and implemented. Can you explain the consequences of having an obsolete legislation that does not reflect the reality of 2023? We're lucky because the Act is based on principles, so we can apply principles for an organization that is using data and disclosing data. That's why we are able to investigate ChatGPT and TikTok. But there are some shortcomings because we don't have order-making power. We don't have the power to give out fines. So that's a shortcoming. Maybe that wasn't an issue then because there wasn't a lot of money made with data, but now things have changed. There needs to be more proactivity and more transparency. Need to be able to explain decisions made by algorithms and AI. That didn't used to be an issue. It can be focused on with principles, but it's a little bit more technical. When we're talking about AI and algorithm decisions, it may not be adapted to the successors of ChatGPT. Thank you, Monsieur Blanchet-Jonca and Monsieur Dufresne. Last intervention for Mr. Boulrist. You have 2.5 minutes. Thank you. I have 2 questions if I have time. In your opening remarks, you talked about protecting children and teenagers. How can we be sure that if there's a minimum age to create an account, I think it was 13 years old for TikTok, 14 for Facebook. I think that we know that a lot of teenagers and young people can circumvent those rules and create an account. What is the responsibility of companies and of the government to ensure that those minimum ages are respected? Because it seems to be quite easy to create an account. Answer. That raises the age verification process and how to determine if a person is a minor or not. That'll be very important with C-27 because the information will be treated differently. That is something that we are focusing on in privacy. We talked about this with the UK and their office that created verification tools, and we've stated that those tools need to be appropriate. They can't go get too much personal information because you want to verify the age, but you don't want to go get too much personal information to do so, but there are ways to do that. It's another example where we need to be creative, and it needs to be adapted to the context. Perhaps some sites will be more risky, and so the verification will need to be more aggressive. For example, for gambling websites or pornography websites. And there are other websites that'll be less sensitive, that might be more for children. And so it'll be important with the legislation, and my office has a role to play because we can create some guidelines and we can create a code of practices and programs, and that creates an incentive for organizations to become members of a series of rules, and if they respect them, well, it has an impact on the complaint process, and it would be advantageous for those organizations. So that's an additional tool, and I think that we'll be able to work on that and include these details. And my office also plays an advisory role. So companies, especially small and medium businesses, can contact us with their specific questions, and we can support them, especially for more technical issues. Thank you, Monsieur Dufresne and Monsieur Boulris.
Before we go, first of all, I want to thank you, Mr. Dufresne, for being here today. I know a couple hours, a long time. You were solid as always, and Mr. McGuire, thank you for being here. You were solid in support, and on behalf of Canadians, I want to thank you for your service to our nation. My understanding is, I did catch up with Mr. Barrett, that there is consent to extract the first hour TikTok information into this study, so we will do that, and we will make sure that the analysts do that. That's it for today. I want to thank everyone. Thank you to our clerk, our analysts, our technicians. Meeting's adjourned. Thank you.